I'm not going to say Mr. Steele didn't argue about that during the hearing, but he didn't ask the court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was no ruling on fruit of the poisonous tree. We're not talking about a second bite of the apple here. We're talking about him now challenging a search warrant that was not challenged before. And I think
though, that's the thing about it. I mean, I think it's clear from reading the transcript and the exhibits 1 through 10 that were admitted when we were here on the 17th of November that he challenged everything: the arrest warrant, the search warrant.
I got a sound wants to mess up.
And he, in fact, he filed a supplemental motion to that extent. So Judge Newkirk granted the marijuana was only the subject matter of what you prosecuted him for at that point in time. You had other things that were seized. Those things are fruit of the poisonous tree, or the minimum should have been.
Yes, I know the
And so, Your Honor, I do want to pivot that if this court right now today.
So I know the audio was cracking. It actually wasn't cracking. Literally just 2 seconds ago, it was not cracking at all. What's up, everybody? Welcome. Young Thug is in court and it's live, and I didn't know, but now I know. So now we're gonna watch as much of it that we can. So hold up. We're gonna try to figure out what's going on with their audio because the shit was just working 3 seconds ago.
It says we didn't get to that hurdle. So this is our
okay. We're gonna go ahead and refresh. We ain't got that's ridiculous.
You're ready for that next step. Ready?
Okay. So it's not my audio. Let's go. Let's see.
Now and told them, but I don't think we get to that hurdle because of the lack of authority shown to the court that they had permission to enter the house on the front side. So I don't think we get to that hurdle. There is no ruling on fruit of the poisonous tree. There was no previous ruling on the cell phones. To the extent Mr. Steele wants to make an argument about the other search warrant in the other case, that other search warrant, we can do that today. We have the witnesses here. If this court can make a ruling whether that search warrant was proper.
I know it's cracking. Just try to listen to it as much as you can.
We will explain the delay. We will explain that there was not the appropriate software available at the time of the warrant. We'll explain why all of that was lawful. But there's been no time to litigate that. The question now is whether there was a previous ruling on the fruits of the poisonous tree, and Your Honor, there just wasn't. And Your Honor, we have here the law enforcement, I do mention this briefly in my case, there was no finding that his rights were violated. There was a finding that the state did not meet its burden. Here, the officers acted in good faith. Again, we are prepared to show that there were proper warrants for everything. We haven't had that opportunity yet to show as to the 2016 cell phone warrant. We're ready to do that today. Now, Your Honor, there has just been absolutely no ruling as fruits of the poisonous tree.
Okay, so yes, it's doing it even on the lead attorney's channel. So it's everybody. So sorry, y'all. Let's refresh again.
Do it all behind the wheel of a capable new Kia SUV. Whatever your next adventure, the award-winning
Damn, so it went out?
Thank you guys for coming.
Okay. So was that it? I'm trying to figure out, damn, is that it? If that's it, that went by pretty damn quick. Y'all said it's the audio from the court that's doing that. It can't be fixed right now. Ah, okay. Slime, we'll talk about that a little later. Other stations having the same audio issues. What the hell? What? Okay, wait. Let's try to refresh once again.
So you don't even need to wear a bra. It's a full body shaper.
The ad coming through clear as fuck
doesn't
though.
Roll up. I've likely got.
All right. And it says, except as provided in, 17.555 or 17.556 subsections D, E, and F. And it goes on to say, when a final verdict and judgment is entered in finding the defendant guilty of the commission of a crime, any personal property used in evidence in the trial shall be returned to the rightful owner. All personal property in the custody of a law enforcement agency, including personal property used as evidence in a criminal trial, which is unclaimed after a period of 90 days following its seizure or following a final verdict and judgment in the case of property used as evidence, which is no longer needed in a criminal investigation or for evidentiary purposes in accordance with 17-5-55 or 56 shall be subject to disposition by a law enforcement agency. So this one is different than 17.530, which is pre-trial. So this is trial evidence, what we do with evidence after the trial of the case. So that, and I mean, I still have an issue of that because you would have still had to return his property to him.
Your Honor, I'm sorry, I have to respectfully disagree with the court here. It's not a situation of what Mr. Steele challenged at the previous motion. It's what was ruled upon. There was no ruling upon the.
So if I had $200 and this situation happened, you wouldn't have to return the $200 to me if I won my motion to suppress?
Your Honor, if I had a search warrant that was valid, currently being executed for your $200, and it was for a separate investigation, a separate case, my position is that no, I would not have to return it until that separate investigation, that separate case was done, because I had a valid search. And obviously,
do you have some case law that interprets 17-5-30 in terms specifically the possession of which is not otherwise unlawful? Because that to me says that would be any contraband, weapons, or things that you're not required to, not allowed to otherwise possess. But it doesn't distinguish on investigations or you holding on to evidence that otherwise should be returned.
Your Honor, I don't have a ruling at a case at this time. I'm happy to provide that in a supplemental filing. But again, my understanding of the law is and has been that where there is, if a search warrant is currently being executed on a cell phone, for instance, the police are allowed to retain that property as part of an ongoing investigation.
But he won the motion to suppress.
On the marijuana case, Your Honor,
You took more than the marijuana. He wouldn't get the marijuana back anyways. He wouldn't get any cocaine that came back anyways. He wouldn't get a gun back if he's a convicted felon. But anything else that was proper, that was taken from that particular, house subject to the warrant, that's not otherwise illegal, is returned. The 17.530 says shall return and not be subject to further prosecution, because that's the whole thing about it is, you don't get another bite at the apple based on this particular evidence. You can go ahead and do some, a separate investigation or whatever, but this evidence is supposed to be returned to the defendant.
Your Honor, our position remains that because there was a separate ongoing investigation for which a valid search warrant was in effect, and there was no ruling as to fruits of the poisonous tree, there was absolutely no reason to return that cell phone. I'm happy to provide the court with an additional brief, but that is our position at this time.
Okay. All right. I'm going to take 5 minutes, okay?
Thank you, Your Honor.
Okay. All right. We're going to be in recess for about 5 minutes. Okay.
Order the court, guys.
Ooh-wee. Boy, they fighting over that shit, ain't they? Oh my God. Easy Brown said, come through, Judge. Facts. So was Gunna gonna take the fall? I mean, not Gunna. Is Young Thug gonna take the fall for all this shit? Oh my God, I wish they was. I promise you, that shit will break the fucking internet. I don't know the way Gunna got out. I don't know, sis. Young Thug might be taking the fall for all of it. Young Thug was the head of it, though, right? He was the head of the YSL. I just caught it live. We just watching it and catching it together. I haven't been watching it like that, so I wish I could give you an update. But they was just fighting over property. The attorneys and the judge, and they're going back and forth about the damn property. Oh my God! Just get the shit back.
I didn't see it.
The other co-founder took the same deal Gunna got, 1 year, served in 9 years probation. Holy shit. Well, that's the thing. Yeah, the cell phones definitely have a lot of information in them. The cell phones is where all the fucking evidence is at. Like, we know that. All right, I don't want to miss nothing. I don't know. For everybody asking about Tory and May's case, I don't know why it's not live. I don't know. We're not gonna talk about them over here because it's not the video for that.
I got one more. Yeah.
Oh, there they go with that shit. Oh God, there they go with that shit. Shit's annoying. Is their audio messed up, or are they just doing that on purpose when they don't want us to hear some of the shit they doing? Maybe I'm just not in the mood to hear that bullshit today. Who changed the jingle and shit? It got to be Young Thugs, I guess. Or whoever else is in the courtroom. Hold up. Look at that shit. Like, what is that? Can't stand that shit. It's done purposeful. That's that nursing cough. If the judge saying they have to return it, I don't understand how they can tell him he wrong and keep arguing the fact. Because that's what they do in court sometimes. They sit there and have a fucking shouting match with the judge. Okay. Now the audio is quiet. Who the fuck is that? Who is that nigga? Who is that ninja? Lord, it's some. That look like a young motherfucker too. Damn, I'm cussing a lot. I don't feel well, y'all. That's a little young motherfucker too. Who it? Wait, oh shit! Hold up. This shit is horrible. Hey, yo, is this shit open to the public? Every court proceeding is different. Some show online, some don't. Is this open to the public? I'm gonna have to figure out what time court start because damn, actually, no, I ain't got time to sit in court all day though. That's who is that? Fuck, who is that? How many of them is it? Oh my god. Hold on, I gotta refresh. Let's see if the audio will come back.
Arnold Small Slice. I wonder if this has the same quality ingredients as the original.
Ads come through like a motherfucker though. Like, yeah, like who was that light skinned ninja? All right, let's see. Still nothing. It's mute. They muted that shit on purpose. Raggedy motherfuckers. This is when the good shit happened and we can't hear the shit. Damn, ear itching shit. It's 4 of them total charging this, not including Gunna. I was gonna say because I'm like, what? I mean, I knew they had got like the whole gang because it was literally a whole bunch of the niggas. Like I know that, but shit, there go another. Tamara said, allegedly they all taking a plea and gonna blame all this on Thug. YSL started in 2012 per the co-founder. Damn. Yeah, Thug gone, y'all. I don't know what to tell you. We'll see. We'll see. I don't know what the fuck do I know, but just saying. I'm so lost. Listen, I'm lost about it too. I don't, Miss Ray, I don't keep up with these ninjas. I'm doing it for y'all that do keep up with it. I caught it. I didn't even know it was going on today, so I hopped in with it. You know, everybody been talking about the Meg and Tory shit, so we kind of let this fall by the wayside. And ain't that 5 minutes up? I thought that judge said a 5-minute recess. I thought them 5 minutes was up. He can't have much in it now if he got it back right. The judge is hungry. They always fucking hungry. Thank you, Christina. Christina gonna be my co-host today. Appreciate it. Wait, so did he know Gunna took a plea? I don't know. I'm assuming he know by now, but I don't know. Facts. You better not be late for your court case. They'll go right past your shit. Mm-mm. The whole jail know when someone tell, wow. Wait a minute. So that means if if Gunna, now that he done snitched, allegedly, if he gets locked back up, ain't he gonna get fucked up? Like if you a snitch and then you end up getting sent back into jail, like don't you get messed up? I'm assuming. Come on now, some of y'all that done some time, y'all tell me. The sister to Thug went on OGB Live this morning. Said Thug was surprised when he found out he had no idea. Wow. They said yes. Yup. Stitches. Ooh. Damn, he got to stay out of trouble. Then I guess the question is Gunna even going to be safe in Atlanta? No, because he not like that. He not a street nigga. Oh, okay. Gunna is not street. That man's about to be a very pointed square. Oh no, Dingo! You said protective custody. Those guys sitting in protective custody where they're safe and they hang out with all the other snitches. Oh no! Ouch! Yikes! Young Thug's sister says, "Stop calling Gunna a snitch." Listen, people can talk all they want, but if you got the opportunity to tell and get out, you gonna tell too. That's why I tell y'all, you do some shit, you do that shit by yourself. Because when push comes to shove, it's very few people that's really built for that kind of life. And I know I'm not one of them. I live a square life And I am not mad about it. Mm-mm. Gunner was on Crime Stoppers before his career. Maybe in 2011 you could pull it up. Oh, okay. So he didn't pretend to be that guy. So okay, I guess my question now is, how did he get caught up with YSL? Or did YSL like fund his rap career? Because a lot of their rap careers be funded by the gangs, and then they be indebted from, like, you know, from Jump Street, and they gotta kind of claim the gang, but they're not really in the gang, but the gang kind of owns them. You know what I'm saying? The gang is just kind of like always there. Why the fuck they still on break? Because the judge on the toilet, probably. That judge probably back there eating some motherfucking 12-piece lemon pepper flats. It's hip to be square. Oh, he was on crime watches for his cousin who was wrongly accused of murder. Ah, okay. See, all that's before I was a blogger and way before I lived in Atlanta. So y'all schooling me. 2011, yeah. Gunna is like a little brother to Thug. Well, was right. Yeah, I don't know what they're gonna be after this. Okay, wait, they moving. You know, these some fat ass bailiffs too. I'm trying. Oh, I hope don't none of them watch the show. No shade, but I'm trying to figure out if something really go down, who are they chasing? Wait, are these bailiffs? Nah, not bailiffs. Secure? They not secure. What in the hell are these? Or just are they? Are they called bailiffs? Listen, it's been a while since I've been to court. I'm just saying they waddling. They look old. Look up. Who is she chasing? No shade. She's waddling. Court officers or bailiffs. Okay, thank you. Sis waddles. Who is she going after? Who is she going after? She got that auntie booty. Y'all see her big old booty? She got that auntie booty. Why? Look, they all do. His belly all over his belt. Them pants too small for him too. Him and the dude next to him. Homie over there looking like Colin Powell. There go another sister. She wilding too. Who are they go? They just gonna have to shoot a nigga. Because who are they wilding? That black man not that big though. But if you're gonna have that job, you need to be in shape. I'm not trying to be funny. I'm really not trying to be funny. But like, you need to like, I'm not trying to be funny. No, she had an auntie booty. She looked like she need to be behind the kitchen somewhere cooking us some motherfucking collard green cornbread. You know, I'm just saying. Nah, because I used to work for security. When I worked for Securitas, even though I told them I wasn't securing shit, my job was to observe and report. But maybe I was 150 pounds. So I could at least run. And I used to take a kitchen knife from my house. Oh my God, it was so bad. It was just. Anyway, they call it unarmed if you want. Yeah, his belly over his belt too. Nah, man. But anyway, they literally they measure you, they give you opportunity to, get the correct size for your uniform every year. And I think people don't be wanting to, I'm just saying. He got neck fat over his collar. Storm a kitchen knife? Yes, a butcher knife. Yes, I don't play. Now she look like she don't play. She look like she got hands. I can tell by the way she walk up. However, who is she running after? No shade. Oh, no shade. I said no shade. She's not even big. So I didn't say she was big. I'm just saying. Who is this running after? You know they not passing no physical exam. Keep it real. They might have passed it to get the job. They not passing that shit today. Yeah, I know that other lady had auntie booty. I don't know, man. Okay. All right. Thank you, madam. That's what I'm saying. It gets real with these criminals. Like, you be looking, you be like, are they retired cops? I got a feeling they might be. I got a feeling they might be. He moving slow as hell too. They're all kind of like what, like no shade. They're all kind of like waddling. She probably will run you out your shoes though. Let me tell you something. She might, but she gonna be huffing and puffing. She gonna be huffing and puffing, and she gonna beat your ass when she catch you because you made her run. Gotta love our judicial system. Where the judge go? Right, that's what I'm saying. Where is the judge? I promise y'all, I couldn't be no judge because man, I want to come to court my damn do rag, wife beat up. Oh, they're gonna Wonder Bread. They're gonna another Wonder Bread. He was. Oh, he looked like an attorney. I sure had my wife beater on under my robe. I would want to get some head with the robe on. Give me some head under this robe. Oh my god. Oh, I know something wrong with me. I know that's so messed up. That shit would be so sexy to me though. Come to the court after it's locked down, let myself in. Come give me some head on this robe. While I beat the gavel. I sentence you to 2 hours of dick sucking. Boy, y'all better hope I don't marry somebody as freaky as me. If I marry somebody with the same freak level, it is over. I don't know what kind of person I'm gonna be. I'm sorry. Yeah. Dude, you gonna focus on this Creole looking brother, but where's the sound? Y'all say I'm a freak, man. Listen, y'all heard about that cop up in Phoenix that got fired for doing porn on the job. Listen, shout out to Rico Blaze. I need a brain stomach hurt. Ooh, that dude look like Terrence Howard daddy. Who is that? A lot of y'all don't know. I've low-key like had the flu since Sunday. I feel a lot better now, but do y'all know I really literally haven't really like ate since Sunday? I managed to eat last night though. I had some noodles, and the night before I had some noodles too, but that's really it. I have been living off of Pedialyte and motherfucking ginger ale. Shout out to them hood prescriptions. Maybe that's more country, not hood. Glad you feel better. Thank you. The flu. Nah, I went out of town and I think it was that food I ate that honestly got me sick. I think them niggas was coughing in that shit or something. I don't know. All right, he looked irritated. I'm gonna refresh. Let's try this again.
Forward is tools like Home Insight that help you navigate the home buying experience so you can move on to what's next. Because life's certainly not standing still. PNC Bank. See how we can make a difference for you.
Ooh, he looked angry, irritated. Storm drink a hot toddy. I may need that. I'm definitely on the upside now. It's some going around, like for real, for real. The shit had me in November too. I was like, damn. November took the fucking cake. I didn't even upload for like 12 days in November. I couldn't fucking like hear out of my ear. Listen, I'm gonna say this. Ever since I had COVID, I feel like my ass ain't been the same. I don't know about y'all. Anyway, this ain't about me. He mad he didn't finish those wings. Judge with the earring. Oh, you mean to tell me I could be a judge with the earrings? Oh shit. He better not be old school and only had that one piercing. Sir, if you don't pierce both ears, they be getting me with that. Still thinking it's gay. We know, sir, you 60. We know you ain't gay. Oh Lord. Hey, okay. Who did the Thugger's hair? Oh, they got beauty. Well, you know what they sure do. Cause they do be keeping their hair together. They do. You right. You're right. Cause even homegirls be having micro braids when they be in jail. So you know what they sure do. Yeah, they can cut your hair, all that. Yeah. They did this her good, whoever did that. Oh, can I ask y'all some? Ooh, is Thug straight? No shade. Is Thug straight? I don't know. And I hate when people ask this about me. It ain't none of my business, but I feel like he used to wear skirts, but I don't know if that was just an act. Is he straight? Mm. Straight-ish. He has a girlfriend. Hell no, no. Oh, bisexual. Okay. Okay. Oh, okay. I think he's fluid. He's straight but dressed non-binary. Okay, that's the thing. That is the thing. They say he's bi. Oh, okay. Gotcha. Okay. Stop fucking with the mic. He's straight. He just does what he wants when it comes to clothes. Did the judge not prepare? Ah, golly. So what? I was gonna say, what happened in prison if you can't afford to get your hair done? Like they do your hair, and then you like, oh shoot, I ain't got no money on my commissary. Dude, what happened? You had to give us some ass. I'm just asking. I'm just like, that place is a whole nother set of rules in there. And I know booty is the highest currency, even more really than food is booty. More than water, more than candy, more than chips, even more than ramen noodles is booty. So Christina said this a watch party. Yes, it is. They don't have their stuff together. They literally do not have their stuff together. That's sad. And they professionals. Supposed to be. And they cut the mic again. Now they couldn't do all this in that damn recess they took. Yeah, this is in Atlanta. That's one thing I noticed about, well, just anything down here. It is slow. We got to do better as a people. Why is it so many? All these attorneys. What is this shit? Who was sitting next to the man with the white hair? Shit, I don't know the hell if I know. I can't see it. Is that Young Thug? Right there? Is that him right there? Shit, I can't see till they zoom in. You know, all of them start to, no shade. All these rappers start to look alike to me. I really don't be knowing them apart, honestly. It's so bad, but true. Who said, can I fast forward? You know damn well I can't fast forward no live ass court. Why Sandra say? Why Sandra say you sound like Nelly when you say right there? Honey, we're from the same place. That's why. The fuck? I don't want that shit in my ear. Damn. What they do that for? They don't want us to see the good shit. Why you even giving us the feed then if that's what you're gonna do? It's only so much shit they want out. We want to know the good shit. But anyway, I look, it's my motherfucking job to entertain. Y'all know how I was trained. We don't do no dead air in this motherfucker. Okay, well, damn. Well, okay, well, that's that. Y'all know we can't do that. Anyways, it's all the stage. They didn't pay their bill. Or is that it? Hold up. Because if that's it, that's it. Okay, cool. So unprofessional. So nasty. So rude. Who knows where that's from? So nasty. So rude. Oh my god. Hold up. Let me check on this other channel. Let's see. Okay, yeah. I think that might be it, guys. I literally think that's it. I think they cut it there for a reason. they said Nene, so nasty, so rude, so nasty, so rude. Mm-mm-mm. Mm-mm-mm-mm-mm. Did the mayor ask for it not to be broadcast a lot? I don't know. I do not know. But listen, people, we still are going to be doing the Storm After Dark this Saturday. All right, on OnlyFans. The link is in the chat. All right. We'll talk about it later today. I think I'll give everybody a free trial again. See, I could come over there, watch the podcast with Love Jones and I, and see if you fucking with it. The topic for this Saturday is MFM threesomes. Okay. Is it a train? Is it a threesome? The good, the bad, and the ugly. It should be interesting. Because this topic was a personal request. Oh, they shutting down before 4. Okay, that makes sense. All right, cool. At least we caught a little bit of it. I'll do my best to catch it tomorrow so we can see it from the beginning. It's on Fox 5. Hold on, let me see. Nah, it's still the same. They cut it. MFM, yes, MFM threesome. So that's male, female, male. So Love Jones and I will be talking about that this Saturday on Storm After Dark on OnlyFans. Hold up, I'm gonna see if I can see Young Thug and Court on anywhere else. Okay, let's see. Love Jones, yeah, we love Love Jones. Yeah, nah. I think it's shut down. Yep, they shut it down. Okay. That was fun. All right, I'll play with y'all for about 8 more minutes and then we'll go. And then I found what I needed to find. So yeah, we'll come back. Do an update on Megan Tory. Then we got to do our skincare sponsor live. I got a interview to do, and I'll see how I'm feeling after that. But anyway, are you gonna have call-ins? Only no. I don't think I'll be able to do call-ins over there yet. But I do know that like you guys can comment and we can literally just like take y'all questions and stuff. So yeah, I don't know. We're gonna try it on OnlyFans. Like I said, if it doesn't really work with OnlyFans or if it's kind of funky, I just want to try it because it's different. Because everybody's like, okay, we on Patreon. Okay. Everybody's on Apple Podcasts. Okay. But who really starting a podcast on OnlyFans? You know what I'm saying? Especially where there's no rules. But anyway. But we'll try it. But if not, we'll put it somewhere else. Times. Okay, that's gonna be 9 p.m. on Saturday. 9 p.m. because that's definitely a late night show kind of a thing. Let's see. Take a teaspoonful of honey for your throat. Nah, my ass need that Dr. Sabi diet. Is what I need. When you listen, I guess we can just talk now. How does OnlyFans work? How much is it? I mean, it's only gonna be $9.99, but I'm gonna give y'all a free trial to come over, of course. So don't worry about that. Don't even worry about that. Okay. So let me. Damn, what was I about to look up? Yeah, we just have to do we have to pick a day for it. I wouldn't mind, Charnel. I have to pick a day for it. That's the thing. And I gotta stick to the day. Because if I hop around days, it gets confusing. So I will announce that. Just stay tuned for that. I ain't forgot about y'all, but I will announce that. Just stay tuned. Let's see. I got rid of my cold in 3 days by taking zinc citrate. Child. All this different shit. Raw veggies once a week. Nah, my ass need to probably be raw veggies every day. Honestly, I probably need to be like raw veggies every day. Because the only thing was, nah, I ain't gonna go there. But yeah, probably need to do that like every day. What was I about to say? Meat only twice a week, right? All that shit all that shit really keep mucus in your body, which keeps you sick. So okay, I'll put that up. Thank you. Pozole. You was gonna look at your phone and check a date. Okay, I was. Oh shoot, yeah. Can y'all still hear me? Y'all should be able to. I don't know why I was saying I unplugged myself. I didn't unplug myself. You were talking about Dr. Sabi's diet. Yeah, I was, but no, I'm kind of just hopping around, whatever, to finish up an hour here. But no, so I got 30 days to be out of this apartment. Oh my God. And I don't know where I'm gonna go, but I'm gonna figure it out. But 30 days. I'm excited though. I'm excited. Like, don't y'all remember when I had like first got in here and then all that drama went down? The car got stolen. Everybody was like, "Are you gonna switch apartments?" I was like, I kind of can't." 30 days. 30 days, baby. And it's already been rented out. So yeah, I gotta go. I got to go. Where? I don't know. But it can't be up in here. 30 days. Was that a year lease? Yes, ma'am. That year went by fast. 2022 went by fast. It went by so fast. Oh my goodness. Keep making videos and you'll like, oh yeah, I will, of course. 2022 was a good year. You know what? I'm blessed to have made it through. For me, it wasn't personally, it actually quite sucked. Like when I tell you I'm happy to leave this year behind, I am happy. Yeah, that's what I'm saying. 2022 was messy. This was a messy ass year. Like I said, I'm grateful to have made it through because a lot of people didn't. But messy motherfuckers trying to fuck with your money, putting your name in they court cases and shit that ain't got shit to do with you. It's been a lot. It's been a motherfucking lot. People that you thought was cool with you, it's been a lot. That's all I can say. But God is good. God is good. Who stole your car? I am not telling y'all. Not now. Maybe a little more time go by. Actually, no, I won't because I have the spiritual confirmation, like I said, but I don't have the physical confirmation. And so I don't want to get sued. And so I probably won't ever tell y'all honestly on any platform, but nonetheless, I do know exactly who did it. I know why they did it. Not your name was in a case, baby. A couple cases. Motherfucker, a couple motherfuckers. It ain't even who you think it is. I'm referring to somebody else. Dude, my name is some shit, bitch. I ain't got shit to do with your shit, bitch. You mad at your baby daddy? What the? What that got to do with me? I'm like, oh my god, oh my Jesus. I felt like Nene. Like, how my name getting that? You going after your baby daddy? Even the judge told her, "Ma'am, Mr. Monroe has nothing to do with that. If you want to pursue litigation against him, that's a separate case." I said, "Damn." My name is everywhere. Bitch, I'm worldwide. I'm literally worldwide. Oh, they back showing it? Hold up. All right, hold up, y'all. Share the screen. Chrome chat.
Steele. I will lodge an objection at this point. Yes, sir.
Basis?
Basis is that it is attempting to relitigate something that should have been done before. It has no bearing on this motion whatsoever.
Your Honor, we would like a complete record, and if it's already, as Mr. Steele says, in the record, we don't see the harm in simply perfecting the record with a self-authenticating document.
Well, the issue is you didn't introduce it at the hearing in 2017. That was the basis for the ruling for Judge Newkirk. So I don't see why I would need to accept it right now. I mean, because I'm going to rely upon Judge Newkirk's ruling.
We just like to have it in the record, so we may use it just to complete the record, Your Honor, not for the purposes of argument in this particular instance. Should the court wish to rule with us and have a hearing on this, then we'd enter it separately, but for the purposes of the record, we'd seek to introduce it right now.
Let me see it, please.
Yes, Your Honor. It's certified.
All right, Mr. Steele, I'm going to admit over your objection, okay? It states one for purpose of the motion.
And Your Honor, then we'd also just move to admit a certified copy of the search warrant to enter the defendant's home. This was actually attached as an exhibit to the previous transcript. Again, we'd just like to admit this for the purposes of perfecting the record. It's a certified copy.
Okay.
I'll object. It's attached as Court's Exhibit Number 2, pages 57, 58.
All right.
9. It's already, the court admitted that as an exhibit earlier today.
Oh, the transcript was admitted, Your Honor, but we'd like to admit the certified.
Okay. All right. Certified copy. It states 2 for purpose of the motion?
Yes.
Okay. All right.
As Mr. Steele stated, the other one was D10.
Yeah, I've got, that's admitted already.
Is that certified, Mr. Steele? No.
But it was admitted in the hearing on the 17th of November.
May we also tender this as a certified copy of that search warrant, though? As states 3.
All right, any objection? Or same objection, sir?
Yes, sir.
Okay, all right, States 3 is admitted for purposes of the motion.
Thank you, Your Honor.
No, I'm good. Anything else? Anything else in terms of the states and states 1, 2, or 3 for purpose of motion?
Well, Your Honor, we would ask to have a hearing to have the opportunity to show the lawful entry to the house and the search warrant for the phone, but we weren't sure if the court was going to allow us to do that. But if we are, we're ready to do that. We'd like to do that.
I'm not inclined to have a hearing on this, okay? Because, and here's why. The Judge Newkirk's ruling fairly contains some principles of criminal procedure. And even though you've admitted these particular items for purposes of the record, which would supplant bias and some, and would make the issue of that's one argument you could make in terms of the sufficiency of the arrest warrant and the search warrant. The issue still becomes is that that issue was decided by Judge Newkirk earlier, and you all from the state have not given me any. You're still not getting over 17-5-30. There still would be no reason for you not to have returned his property. There's nothing in law that would indicate to the court that you had the right to, to maintain and continue to investigate on those particular items that were taken. But so that's why I don't need to have a hearing necessarily on it, on that particular issue. So with that,
come through, Mr. One Earring.
We would like to proffer what the evidence would show, were we permitted to introduce the witnesses that we have as the court.
I'm okay with that. I'm okay with you all. But I mean, the warrants would supplant the certified copies of the warrants that you have at this point in time would supplant Mr. Steele's argument. But the problem that you're going to have is that 17-5-30 would have required you to still return that particular property. Ooh. There's no case law which indicates that particular issue, and the statute is pretty clear. It says, motion, if the motion is granted, because Judge Newkirk granted that motion, and it shall not be admissible against evidence of movement in any trial. So basically, you're getting a second bite at the apple. And in that particular circumstance, that's why the legislature makes some very specific issues about 17-5-25, which is execution warrants, 17-5-30, which is motions to suppress, and then 17
they fucked up. And they doing their best.
17-5-54, which is different. That's trial disposition of property. So in that respect, that's why in this particular circumstance, you all still, now if you've got another argument as to why you didn't, other than why you didn't return his property, but you would have still needed to return it. You didn't go forward with that prosecution. If you've got some other case law you want me to look at. But it's pretty clear the reason that the legislature enacted this statute is because they didn't want the state.
Oh, come on. Come on. In other words, y'all fucked up. You should have returned the property. You low-key didn't have a legal search and seizure, and y'all trying to cover y'all ass. Oh, man. Oh, he getting in their ass now. She should have set him up. Let me stop.
Yeah, and Mr. Steele's argument is, and just hear me out, you didn't have a valid arrest warrant to begin with. Oh. Now you got one, but you didn't have one when you had one in front of Judge Newkirk. You sought a search warrant, so you weren't in the right place and space to begin with. Oh. Because you went in the house, somebody saw some marijuana, or somebody saw whatever it is, and they, in D10, they got they drew an affidavit, and they said, okay, we want to search the house. Well, you got to be in the right place and space to begin with to have the authority to search the house to begin with. Mr. Steele and his motions asked for suppression of anything that was taken in the house. So marijuana and anything else that was the basis of that. So that's fruit of the poisonous tree. He's argued that all throughout his motion. He's argued that. And so Judge Newkirk, by implication, had to consider it as part of his ruling. So you asking me to kind of, okay, well, the marijuana's over here, that's fine, but he didn't suppress the other stuff. We can still use it. That's not the way I interpret this particular scenario and interpret the law related to search and seizure of this particular item.
Your Honor, thank you. And respectfully, the issue of whether or not the state had a valid arrest warrant is actually proven with respect to, did we have one with the certified document that the court has that the state has tendered as evidence. So it's not a matter that the state did not have lawful authority to enter into the home.
But you didn't have it at the time that Mr. Steele.
We had the search warrant. That search warrant, that certified document that is in evidence, Your Honor, has a date on it. It was signed and filed well before Mr. Steele made that motion, and it was a part of the record of the clerk of court.
But you all didn't.
It was sworn out again.
The challenge is you all didn't take that up on appeal or anything. It was ruled upon by Judge Newkirk.
Your Honor.
So at this point in time, is it fair to Mr. Williams for you to have another bite at the apple? I mean,
no.
At this point, because you're asking me to go ahead and let you use this particular evidence that arguably another one of my judicial colleagues has said, hey, despite the fact that we disagree about how the motion has been styled, clearly it would be subject to being suppressed.
And Your Honor,
and even if I agree with you, okay, let's say you corrected all that. 17,530 is still fatal to you. You still would have needed to return the property, and you haven't given me any legal justification for you to keep that property and continue to then investigate that property or search that property. Unlike trial evidence that clear you could have done that. 17,530 is distinguishable because it's like the legislature seemed to indicate, well, we don't want the state to go ahead and continue to keep investigating an individual based on evidence that a court has suppressed. So that's kind of where I am.
Your Honor, if I may, the distinction is that there was a good faith basis for obtaining the search warrant and for getting the search warrant. A search warrant affidavit for the home itself was sworn out. There was, in fact, an arrest warrant that did exist. It was lawful. The fact that there was not one presented in the 16 SC case is what, yes, caused Judge Newkirk to suppress the evidence as to that case, Your Honor.
Okay, and why didn't you return the other stuff to Mr. Williams? You wouldn't have had to return the contraband. Everybody's clear about that. Contraband or weapons would not have been returnable to Mr. Williams. Why didn't you return the other stuff?
We had actually sought the search warrant, Your Honor, and I think that the court can look at the dates on the search warrant, on the arrest warrants, and see that we had actually already received lawful authority to search. We had already sought and obtained a search warrant for the items. We had already obtained what the state believed was lawful authority.
If Judge Newkirk has already suppressed the marijuana under the same analysis, okay, then why wouldn't the rest of the stuff that you took be suppressible at that point in time and fruit of the poisonous tree?
Your Honor, the ruling by Judge Newkirk came after the state sought permission to search the items. So we had what we believed to be lawful authority to search the items, the search warrants that were obtained, and we have witnesses
Okay,
that will testify.
assume I believe you, okay? Assume I believe you.
Yes, Your Honor.
All right?
Believe that.
Still, Judge Newkirk grants the motion to suppress. The case is over. You can't proceed on the 16 SC case anymore. The evidence that you all took, why didn't you return it?
Because, Your Honor, at that point, we have, from sources, we have probable cause to believe that within items located within Mr. Williams' home, and this is separate and apart from the fact that he possessed marijuana, but at this point, we have information independent of that to believe that within his home, we would find evidence of these other crimes that we were at that point investigating. Prior to Judge Newkirk hearing the motions, prior to Judge Newkirk issuing the order that he issued, even if the court were to see it as more expansive than the state believes that it is, we had probable cause based on information and sources independent of the fact that
when
the
I'm trying to get a girl
defendant
number that's on
marijuana or firearms or whatever it was that was seen when the officers initially entered the home to execute what was and what is. It doesn't change it. The fact that the arrest warrant that was in existence at the time,
skipping like a record,
actually was valid and gave them lawful authority to enter the home does not.
Judge Newkirk ruled that you didn't have that at that point in time, because at the hearing that you had in front of him, or Mr. Bailey represented you all on the 3rd of April of 2017, that was, you didn't have that particular certified copy of the arrest warrant. And so Mr. Steele by argument says, hey, look, I am extending my motion. I'm going to include everything that's in the house because you weren't validly in the correct space and place. Now, had you had that search warrant at that point in time, or not search warrant, but the arrest warrant valid at that point in time, then Judge Newkirk would have probably said, okay, well, then you're fine. But that wasn't that, these particular scenarios have to be ruled upon in terms of what the judge has at that point in time. So, and if you look at that, even if I accept, which I have, I've admitted, states 1, 2, and 3, you still have to return the man's property. He's asked for it to be returned. He hasn't had it returned pursuant to 17-5-30, because I can't go back and unring the bell in terms of Judge Newkirk's. You're not saying Judge Newkirk's ruling was erroneous, are you?
I'm saying that Judge Newkirk's finding was that we had not presented a certified copy of the arrest warrant, which is not the same as that there was an unlawful search and seizure. It's just that the state had not tendered.
On 3 April 2017, that's exactly what he was doing, okay? So you're asking me at this point in time to say, hey, Judge, we can correct that. On December the 15th of 2022, you've introduced states 1, 2, and 3 certified copies of the arrest warrant, the return of search warrant and inventory, and the affidavit for search warrant. And that's why I'm telling you, assuming that
let it go.
How
many times you got to tell her?
The problem that you still would have is the return of property under 17-5-30, because you took the marijuana and the other pieces of evidence from Mr. Williams' home. I don't think the law distinguishes between that. So you would have had to return that. You still would have to return the property to him. So because at this point in time, he's entitled, or he would have been entitled, he's asked, and Mr. Steele has already introduced from in the last hearing on the 17th, he's asked me, or he's introduced a letter that he sent to Mr. Bailey saying, hey, I want the evidence back.
They don't have it.
The court did not rule
They don't have
that the state
exactly.
had
They
to
don't have his
return
shit. Yeah, they
that
stole his
evidence,
property.
number one. There was no ruling as to that.
I disagree.
They probably
I
took money
disagree.
too.
I disagree. By implication, Judge Newkirk had to have considered the fruit of the poisonous tree. Mr. Steele asked him to do that. And it's a snapshot in time. So on the 3rd of April, 2017, you didn't have what you have now. And so you're asking me to correct something that is arguably, you know, I mean, can I do that? I mean, and even if I can, that still runs afoul of 17-5-30. You still would have had to return Mr. Williams' property. And then Mr. Steele asked you for the return of that property. And there's no exception under 17-5-30 pretrial that gives you the ability to keep the property. You have to return the property. The property that, and then you took that particular property, in particular his phone, and then you extricated things out of it, which would be tainted or fruit of the poisonous tree because you didn't have the right to keep that. You didn't have the right to keep that particular evidence under 17-5-30.
Thank you, Your Honor.
Finally, she right. She was fighting for her life. She was fighting, and she still got knocked out.
All right, let me finish what I was going to say. Okay, for purposes of Mr. Steele, you can prepare an order. Okay, sufficient to recap what the court has indicated during this particular.
Come on, Mr. One Earring.
Now, I know that puts us in a position where some stuff that you may have the state was going to admit or utilize. Does that change your position, ladies and sir, about where you are with what would be admissible in this particular prosecution?
Your Honor, there are items.
Is she still talking?
Of course, are affected by the courts suppressing the evidence that was seized back in 2015. There are some items that we believe may have more evidentiary value than others.
He checking his watch. He ready to go. Almost 4:30.
So it does affect the evidence that the state intended to introduce in this case.
Well, I was just asking because if you need to sit and talk with Mr. Steele about what you can agree that would be not admissible at this point in time, given my ruling.
They took the sound again. Excuse me. Yeah, he pissed because he ready to go. Because he took 30 minutes to tell this lady, no, y'all illegally searched and seized you. You illegally took the shit and you should have been returned it. And when you went to court, you didn't even have the certified order. And you can't say it wasn't ready yet. It doesn't matter. The orders have to be certified, ma'am. Y'all didn't have y'all shit together from the beginning. And they trying to cover now. Ugh. We need to go hashtag where that man weed at? Where is that man weed? I'm gonna try to refresh you. I don't know why they do this shit randomly.
Arnold Small Slice. I wonder if this has the same quality.
She back up talking. Like at this point, you don't want to just rest the case. You know what I mean? Like you don't want, like she sat up here and just stumbled and stuttered all over her words. Pixie needs to sit down. We need we need Pixie to sit down. And I bet you that judge, I bet you Mr. One Earring smoked weed too, because he was adamant about you should have returned his property. Return the man weed. Look at all them. Look at that shit. She looked disheveled, confused, old ass HP computer. Now the volume up. It ain't me. They cut it. Excuse me. They cut it. Oh, the judge smokes reefer. Okay, reefer. Sorry. Yeah, that's old school. Reefer. I forgot. You sound like my grandmama that still call it dope. I'm like, dope? You smoking that dope? Dope? Like, hold up. They took $150K from him too. Let's not forget. That's what I'm saying. I knew they had took money too. I said they had to have taken money too. Okay, it's finna refresh, I guess. They damn sure ain't giving that money back, but he needs to sue their ass for it. If he can.
It's at trial.
All right.
Those records were obtained through an order from Superior Court at the request of the former district attorney. They contended that the seizure of their records without probable cause was a violation of their Fourth Amendment rights and that the records should have been suppressed. The court in Kessler found that like bank records, telephone, toll, and building records are not owned or possessed by the defendant, but are business records belonging to the telephone company. The court further stated that the cases cited by the defendant, United States versus Baxter, Katz versus the United States, recognize the right.
Okay.
Right of privacy in the toll and billing records of the telephone company. The court went on to say that neither defendant, as one user of the telephone, nor the other defendant, as its lessee, had standing to object to the production of these records by the telephone company. Further, Your Honor, Regis, R-E-G-I-S-T-E.
One more time, R-E-G what?
I-S-T-E.
Okay.
Versus the state. And that is 292, Georgia 154. It's a 2012 case that is directly on point with what we have at hand. As an initial matter, telephone billing records are business records owned by the telephone company, not the defendant. As a result, defendants generally lack standing to challenge the release of such records under the Fourth Amendment because they do not have a reasonable expectation of privacy in records belonging to someone else. And that's a pen site of 249 Georgia 462 at 469. Accordingly, the court held that the appellant was not entitled to challenge the release of phone records in this case on Fourth Amendment grounds. Your Honor, the issue of standing has to be addressed before the court begins to even look at any substantive matters in this case. And given that the defendant has no reasonable expectation of privacy in the cell phone records of the Hertz Corporation, he has no grounds, no standing. He has nothing that permits him to come in and argue that the court should somehow find that the state's method of obtaining those documents was somehow improper. Additionally, Your Honor, the documents were turned over to the state by the Hertz Corporation. If the Hertz Corporation wanted to contest the release of its own documents, the Hertz Corporation and only the Hertz Corporation, and all that they released, I will also make clear, it's not at all anything comparable to information contained in cell site location data that a person has within a cell phone that they keep on their person and that moves around with them. These documents are simply documents that show that the defendant rented from Hertz a particular vehicle at a particular time and returned said vehicle at a particular time. There's no location information data to which the defendant could in any reasonable way have a reasonable expectation of privacy. Additionally, Your Honor, again, the records do not belong to him. He has no standing, no expectation of privacy in them, and he is not properly before the court contesting or moving that the court suppress the release of Hertz's own records to the state. So again, as well, Your Honor, the law on standing requires that the defendant show that he has standing, and his claiming that, just baldly claiming that the information sought somehow references or, as he put it,
Boy, this is worse than Phaedra Parks. I could not be married to her, I tell you what.
It touched upon the defendant or information concerning the defendant, still does not give him any standing to argue or ask that the court suppress information lawfully turned over that he has no expectation of privacy in, even if it was unlawfully turned over. He cannot argue that the court should suppress these documents. He does not have standing to move the court to suppress the documents. There is no infraction of any law or code of conduct. There is no incursion on any protected rights held by the defendant. He is.
Yeah, it looks like from Kessler that he has a reasonable expectation of privacy in a conversation. He doesn't have the reasonable expectation of privacy in records. So is that kind of sum and substance what your argument is, madam?
Yes, that's an initial matter, yes. And I mean, I'd ask the court rule on his lack of standing before we do anything else related to it. Thank you, Judge. Okay. All right, Mr. Steele, what say you about standing? It looks like that these are the Hertz records, correct?
Yeah, they're included, that's true.
Okay, is that what
he stood up and was the same
as
side.
an initial matter, I would agree with
those
Mr. Lovely, your client does have to have standing. I would agree. I would also tell you that conversations are different than records. So tell me why you think that he has standing to contest these records.
Okay. Well, and when the Honorable Court started to get into this motion, the court actually asked about Mr. Williams' motion to dismiss the indictment and or a motion to suppress evidence and derivative evidence based upon prosecutorial misconduct and abuse of grand jury powers. That was filed on November 3rd, 2022. I supplemented that, Your Honor, on November 10th, 2022. It's the same title, but I wrote supplement to Mr. Williams' motion to dismiss the indictment and or a motion to suppress. It also goes hand in hand, if you don't mind ruling at one time, I believe it goes hand in hand with the Mr. Williams' motion to suppress number 3.
Well, I need to deal with the issue of the phone records. That's what you asked me to do.
The Hertz records.
The Hertz records. So let's deal with the Hertz records first. There may be other issues as to the indictment and some other things, but let's deal with that first. Client's got to have standing in order to address that particular issue.
So I raised it twofold. I raised a motion to dismiss the indictment based on prosecutorial misconduct. Records of another company, although we want to assert standing, Maddox MADDOX versus State says that there is no standing in those records. So I will, under the current case law, I'm not waiving the issue, but I'm telling the court, like I'm obligated to do, of the case law, and Maddox is.
So you would agree the state's proposition is correct?
I would agree that.
But you disagree because you represent Mr. Williams. Have I correctly, summarized that, sir?
Well, it's not like because I represent Mr. I think the law is inaccurate, but the way I understand the law today, we have to follow MADDOX versus State 346 Georgia Appeal 674 2018. It's exactly correct what Ms. Love said, that there's no standing in records of a corporation when you rent a car. But that really wasn't my issue. That's why I supplemented it. And that's why I did the separate motion to dismiss the indictment. And
Judge,
the reason.
If I may, and I do apologize to Mr. Steele, but going into the substance of a thing that necessarily relies upon his right to complain about the state's method of obtaining the records.
You supposed to tell her, hell no, sit your ass down. You talking enough.
Let me deal as a preliminary matter, threshold matter. If that's the case, the records, your client would not have standing. I would grant the state's motion as to that, as to the Hertz records.
Understood.
Okay, so is there any other basis that you are asking for at this point in time?
Yes.
Okay, all right, what's that?
Okay. So, and the reason I want to call Mr. Sprinkle, if you allow me to briefly proffer.
Okay, now, Congress, do I need comments?
Turn out to tell the sit your motherfucking ass down. We listened to you for 30 fucking minutes.
Your Honor, is Mr. Williams is wrongly targeted by law enforcement for 10 years, since he's 21 years of age. And during those 10-year period, there's a systematic abuse of process by the people who claim that other people break the rules, and that's the District Attorney's Office of Fulton County. And what I'd like to call Mr. Sprinkle and prove to this honorable court is as follows. First is what you just heard from. Law enforcement officers and the District Attorney's Office is aware that the Honorable Judge Newkirk found that law enforcement had no right to go into Mr. Williams' home in July 15, 2015, take devices. The prosecution does not restore those devices. You already ruled, I know Judge Newkirk ruled, but that's part of the issues. What right does the prosecution, the District Attorney's Office, have to keep that property and then to send it to Cellbrite without a warrant and have it searched? I want the court to consider that. Then I want the court to consider the following. The fact that the District Attorney's Office did not go back to a judge and say, we have this property, we're supposed to give it back. We are doing another investigation, we want another search warrant. They just go and Cellbrite, I would introduce through Mr. Sprinkle, says, as a courtesy of the District Attorney's Office, we're going to look at this device. I would like the court to have that in its breast when deciding whether there's extreme prosecutorial misconduct. Then what happens is grand jury subpoenas. I'm not moving to suppress anything at this point. I'm not waiving any argument, but I'm not moving to suppress. But this is how the grand jury subpoenas were given out in this case. And it's not only Hertz. It is every grand jury subpoena. I've attached them to the motion. And what the grand jury subpoena shows is that from his office, presumably, Mr. Sprinkle is on every one of these. He has a district attorney seal on the subpoena. The law requires the clerk to seal a grand jury subpoena. Mr. Sprinkle sends all of these subpoenas outside the state of Georgia. There's no authority for a...
No.
What
kind of bullshit is it?
Because the only one that I'm aware of that he has referenced is
How's she gonna cut him off?
Subpoena to Florida. But as a matter of fact, I would just let him continue, and I will not.
You sit your ass down. Why the fuck he ain't checking her motherfucking? How the fuck she just gonna get up whenever the fuck she feel like it? Sit your ass down. You had your time to talk. If you forgot it, then you fucking forgot it. Cross it out. Let it go. The fuck? I'd have cussed her out. Like, ma'am, I don't know if you just getting up to show that you taller than me or what, but damn, sit your motherfucking ass down. Yeah, these jobs is not, them kind of jobs is not for me. I'm glad I left that field. It's not. I don't have that kind of decorum no more in me. Because bitch, the East St. Louis would have came out and been quit. Sit your muck ass down. Nobody talking to you. Damn. Cat had your tongue the whole time the judge motherfucking talking to you. Yeah, the audio messing up now. Now this man beating you. Now you got well, wait a minute. No, sit down. We trying to hear this. They ain't saying shit. She's standing up again. Who clapping cheeks on the mic? I don't know. I know I need some cheeks to clap though. Who's gonna let me clap their cheeks? I need to feel better. It do sound like cheeks clapping. Thank you. He said not nan word. Not nan word. Okay, it's finna refresh.
Subpoenas that he is complaining to the court about.
Okay, so Ms. Love's argument is, and the court's inquiry of you is, what reasonable expectation of privacy do you have, or standing do you have in these records?
This is not the issue. This issue goes to dismissal of indictment for prosecutorial misconduct. Mr. Williams was indicted. I'm not trying to suppress the evidence based upon your ruling and the case law. What happens now is there was such egregious misconduct by the district attorney's office.
So you're saying you'd like to examine Mr. Sprinkle for his motives, or for as to why he sought these particular documents in his prosecution.
I want to subpoena. Well, I have subpoenaed. I want to call Deputy District Attorney Mr. Sprinkle, because I want to ask him why he believes he had any right, which I contend violates Mr. Williams' rights to due process as stated in State versus Lampel, LAMPL, 296 Georgia, 829. It's in Division 2, 2015 case. It's in my motion entitled Mr. Williams' motion to dismiss indictment and the motion to suppress evidence filed on 11/3/2022. And what the Supreme Court of Georgia held was it is an extreme remedy to dismiss an indictment or a count thereof. However, it is a remedy. It's a due process violation. When the state's talking about standing, you can't have more standing than all of these people here who are indicted, wrongly indicted based upon the misconduct of the district attorney's office. And we don't have to sit here and allow the district attorney's office to violate the law and just put us in indictment without this honorable court hearing it. And if this honorable court finds that it reaches the level of outrageous prosecutorial misconduct by the systematic abuse of process by our district attorney's office, then the indictment is dismissed. The state is arguing something that has nothing to do with this motion. This motion is not a motion to suppress. It is a motion based upon a violation of due process rights because everyone here, I assume, joined the motion. Everyone here is suffering from the state of Georgia's unlawful abuse of their power.
Ooh,
that's the
site again.
Mr. Lample's site is .296 Georgia, 892, Division 2, 770 Southeast 2D, 629, 2015. I had the honor of representing Mr. Lample. On that case, it went to Court of Appeals of Georgia, then the state sought certiorari, and that's how the Supreme Court got that case. He's the mayor of Monroe. Mr. Lample's the mayor of Monroe.
Okay.
And that's why I would like to call Mr. Sprinkle, because he's sending out, under the auspices of a grand jury subpoena, with the district attorney seal, without the clerk seal, outside our state. They've taken evidence from Mr. Williams' home, not returning it, searching it, regardless of Judge Newkirk's finding. And then, Your Honor, what I'd like you to consider, and Mr. Sprinkle would be asked, there's a recording in a grand jury, and it happens on June 15, 2018. Mr. Sprinkle and law enforcement officers who were present in this courtroom subpoenaed a woman named Ms. Morton, M-O-R-T-O-N. They brought her before the grand jury in Fulton County. They didn't like that she wasn't talking with them. They put her under oath. And they said, it's Mr. Sprinkle is said on recording right at the beginning. It's at 10 seconds of the recording. He says, because in Georgia, it's not an investigative grand jury unless the court deems a special purpose grand jury. It's not federal court where you could do an investigation. The state of Georgia, you need a proposed bill of indictment already against the person and what the charges are. State of Georgia versus Brian Steele, here are the charges. What Mr. Sprinkle tells the grand jury is, this is not an indictment under consideration. We are just here to hear Ms. Morton testify. That's not valid. So I'd like to ask Mr. Sprinkle what right he had to use the grand jury as a district attorney's investigative tool. Those are my five issues. The search warrant, the search of the devices, which we already ruled. Why did that happen? Why did the subpoenas come without a clerk? Third one is, why would the subpoenas go outside of the state of Georgia? The fourth one is, why wouldn't you return the property? And the fifth one is, why would you bring a human being before a grand jury when you don't have a real bill of indictment, and you tell the grand jury that this is not a bill of indictment under consideration? What right does the district attorney have? And that's why I subpoenaed the young man.
Okay.
Your Honor, the defendant still has not addressed the issue of standing as any of these.
He's indicted.
No, Your Honor. The conduct that he is complaining of, he has to have been agreed. He has to have an expectation as it relates to that conduct.
I think that's what he's asking me to test. I think that's what he's asking me to test. And he's also saying, hey, he's an aggrieved person because he's under indictment for these bigger charges. So,
and Your Honor, if I may, I don't know why Mr. Steele cited Lample in his brief, because it actually supports the state's position in this case. In Lample, a special purpose grand jury investigated the defendant and subpoenaed that defendant. In this case, it isn't even that the defendant was subpoenaed to testify. He is talking about a person who didn't even yield information that was used against him. He is asserting that actions that he has no right to complain of should be somehow used as a basis for dismissing a lawful indictment against this defendant. So he is, I guess, attempting to leverage the court's ruling previously into something that simply doesn't exist. He does not have a right to complain of the actions he asserts were unlawful or improper. He simply doesn't. And he hasn't addressed his being indicted alone does not give him standing to argue or to complain about the fact that Ms. Morton was taken before a grand jury, or that a subpoena was sent to a corporation or a company or an entity that the defendant has no expectation of privacy in. He simply doesn't get past that initial threshold. And by continuing to fold one argument into the other, he attempts to subvert what the courts
I think they just be muting when it's her time to talk, because she talking about bullshit. I know she got a pee. I know she's sweating all up under that tracksuit. I know that Hillary Clinton tracksuit got all kinds of deodorant secret stains the way she been sweating.
Supreme Court, they've been indicted, and when the Georgia Supreme Court says, nope, you lack standing, it being indicted doesn't afford them standing to argue about matters that they have no right to complain about. And so he has bundled up a whole bunch of matters as they relate to other entities. Frankly, with respect to Hertz or any other entity, they can simply give us the documents we requested them. They could literally email them to us, as some of them will do. But the only entity and the only people that have a right to complain about that, and right now he's skipping over the fact that he has no right. He's asking you to jump right to, let's just get into the substance of the argument. And that is not the way that the law works. Mr. Steele is well aware of that. He is a very seasoned attorney. And he is attempting to escape that fact by just pushing forward and conflating all the arguments and making sure that they collapse into one mud pie. But Your Honor, I believe, and I'd ask that the court address that threshold matter before we get into anything else. And specifically, before we begin bringing assistant district attorneys in to talk about what could constitute work product and to discuss matters that have nothing to do, that are in no way matters that the defendant has a right to complain about.
Y'all not ready to go home? Yeah, like it's 4:56. Ramen, that's what I'm saying. I had ramen soup last night. It was bomb. Do you hear me? And I added some egg and Fritos to it. But that was all I could really take. Has she even been doing any work on that computer? right. I guess we trying to figure out what we gonna do. Storm have pregnant women taste. Oh no, baby. I used to eat that as a kid, baby. You make them noodles, you add some fried bologna, eggs, Velveeta cheese, you add all your seasonings to it, your Louisiana hot sauce, then you get some flaming hot Fritos, Cheetos, the Funyuns, Doritos, and then crunch them in. Oh my god. With a great vest. Oh, you don't even know. Mm, 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 mm. Nah, I promise you, it's good. I've never had. No, I have had Texas Pete hot sauce. It is good. I take that back. I have. Yes, get that great vest. You can get the cream soda, strawberry. Oh my god. Then get like a side of cornbread, Mrs. Butterworth syrup, pour it all in there, warm that bitch up, let it get hot. Oh my god. And then stick the syrup in the corn and pump it. Oh my god. Yeah, I don't even know. I don't even know. I don't think Tapatio better than Louisiana. I like Tapatio too, and I like Cholula. Tapatio just goes with different foods. The flavor's definitely different. Cornbread, yes, cornbread.
I'm just listening. I'm not doing anything, but I have to listen to this. Sam's got a project, and it had to be printed on a post. The poster printing printer at FedEx is broken, so is the one at Office Max.
What? Who is that? Somebody say Old Bay hot sauce. I've never had Old Bay hot sauce. I figured that would be salty as shit. Did you say syrup? Yes, syrup on your cornbread. Yes. I like Crystal hot sauce too. Yes. Oh, I like Valentina too, Nicole. Especially on tacos. Yes, ma'am. Mm-mm-mm. Yeah, put it on your cornbread. Oh my god. I like Frank's too. I do like Frank's too. I'm not gonna lie. I do like Frank's too. I'm just always gonna be the biggest fan of Louisiana. And now Tabasco is like an alternative for me. I'm not the biggest fan of Tabasco. But I like the green one more than the red one. I'm gonna try honey or syrup on cornbread. Baby, do the syrup and get it all slopping wet, get it nasty and thick. Let that shit roll over to the sides. Like your whole, like by the time you get done, your whole mouth, your face, and your hands should be sticky. Take your clothes off because it's gonna be a mess. Because you're gonna be sticking from every which way. That's how I eat my cornbread, at least. Now everybody don't like their cornbread like that, but I take that syrup and then I'm so nasty. And then after I ate up all the bread and I got all that syrup at the bottom, I take that bowl and my finger and I take that. I be licking that bowl for hell. I don't give a shit. None. Oh my God. I would lick the hell out of a plate. Mm-mm-mm. And go back and get seconds. Storm, you should do a mukbang. I've done it before and it was actually hilarious. Who remembers the Saweetie meal? And they forgot my Saweetie sauce. Take your shirt off because the way I eat it, you're gonna be wet and sticky all over. Come on now. Unless you like your shirt sticky. Saweetie. What if you in public? I don't do it in public, but I do clean them bones, them chicken bones. I don't even that Papados. When you get that half chicken, I cleans the bone. You gotta break the gristle, suck the stuff in the bone marrow out. When I get through, it look like a dog ate that plate. At least that's what they used to say when I was a kid. It looked like a dog ate my food because some of y'all don't know how to eat chicken. It's fucking hilarious to me. Like take 2 bites of chicken, put it down, get a nut. Like it's blasphemous, but whatever. No audio. It's gonna take them a minute to refresh. You're funny. I'm for real. So you really know what you listen. You got to get in there. Damn, not the bone marrow. The bone marrow. I cleans a wing. All that meat gone, gristle gone. Mm-hmm. A lot of y'all don't know how to eat ribs. A lot of y'all just you got to get in there, put it in your mouth. Shit, y'all be playing with it. But anyway, I forgot all about corn. I'm thinking about food now.
Mr. Bailey's, not Mr. Bailey, but Mr. Sprinkle, you're challenging by way of the evidence that you were presenting, or that I said you didn't have any standing to see what Mr. Sprinkle in fact did present to that grand jury and what he told them. So
I actually won't do that. What I'd like to do is, why did Mr. Sprinkle serve grand jury subpoenas? Why did he do the process the way he did? I'm not going to ask anything about what happened in grand jury, except I have that recording that was given to us in discovery.
Was it discovery?
Yes.
Okay.
I'm trying to make myself hungry. I'm trying.
Will not ask anything about what occurred in grand jury, except what was given to Mr. Williams in discovery by the state of Georgia. It's a recording.
Wes, do we have a copy of the motion of service? Yeah, that's what the motion was.
That man had to get him a little snack. I bet you eat some real good. I do. I do. I'm a short nigga. I have to be able to do that. Yes, ma'am. I put as what Kwame Brown say. He put his whole head in it. My whole head be in it. And no, you are not gonna suffocate me. I put my whole head in it. It is not a time to be cute. I have to represent. I'm sorry. I can't play games. I'm just telling you. Hey, you're not done when you're done. You're done when I say I'm done. And I can go for a while. So I'm just letting you know. Yeah, I don't play when it. I'm so serious. I don't play when it comes to that. Oh, goodness. You hear me? Don't give a shit. I never understood dudes that didn't want to do that. I don't know. Whatever. I'm a lame nigga though, but I just you better get in there and handle that. Where I get them in to do to my 2 years old.
Okay, I ruled upon the issue of the all right, I think I'm back on at this point in time. In terms of the motion to quash the business records, I'm also going to grant the motion to quash the subpoenas, both subpoenas 1 and 2. The court is of the opinion that of the relevancy of these particular records, but also they're protected by work product under 24-5-501. And for those reasons, I'm going to deny, I'm going to grant the state's motion to quash on those 2 subpoenas. All right, anything else?
Thank you, Your Honor.
All right. I have some proffers I need to deal with. Let's see, Mr. Where is he? Mr. Hoover?
I'm sorry, Your Honor, before we do that, I just want to bring the court's attention. Mr. Kendrick has voted to suppress statements on the record. We have a witness here, a spoken counsel. He doesn't intend to go forward on that motion.
He does not intend?
We were hoping we could release our witness who's in here instead.
Yes, any objection, counsels?
No, just to be clear, we're not withdrawing the motion. We would just like to argue that on another time.
And your name again, I'm sorry.
Doug Weinstein, W-E-I-N-S-T-E-I-N.
Mr. Weinstein, what's your client's name again?
Kendrick.
Sorry, Your Honor, we're just hoping our witness might be able to go.
Well, you know, the folks, I like to be able to accommodate everybody, but you saw what happened this morning, okay? We had a technology glitch that nobody could have foreseen, I should say, and we're kind of a little bit behind. So we're a little bit behind in terms of just being able to properly conduct court. So, what is your motion? Your motion is to suppress?
Yes, Your Honor.
Could you give me just a few minutes and I can maybe have that motion heard since your witness is here?
No, Your Honor, I believe he doesn't want it heard today, and we don't object to a continuance.
Oh, okay, all right, so your motion is suppressed. All right, we're gonna, okay, all right, I understand.
Thank you, Your Honor.
I'm with you. Okay, yes. All right. You give a mouse a cookie. What is it you want, Mr. Sharp?
Thank you, Your Honor. I just wanted to make sure that I respect the record. I know that you have not ruled on the
It's
motion.
not your turn yet.
Well,
You jumping in front of Mr. Steele now?
no, I am not jumping in front of him.
Okay, all right. What is it you'd like to tell him?
Well, I filed the exact same motion that Mr. Steele filed
And
regarding
your client is, sir,
Stillwell.
Mr. Stillwell?
And that
Okay.
was filed on November 16th. And
The motion to dismiss the indictment
motion to dismiss the indictment.
and motion to suppress evidence. You wish to table yours at this point in time?
I have not heard you rule on the actual motion, just on the subpoenas. And I would just point out to Your Honor that our argument is not based on any Fourth Amendment violation that would require standing, but rather prosecutorial misconduct, which I believe as citizens of the United States, we all have standing to challenge. And Mr. Stillwell, who has been indicted and investigated in part by illegally issued subpoenas.
I'm going to deny the motion to dismiss the indictment. Okay?
Okay, well, I just wanted to make sure it was on the record that I too have filed that motion and.
All right, I'm with you. Okay, all right. So to the extent that's been ruled upon, that's fine. Anything else?
Actually, Judge, just while we're here for the record.
Yes, Mr. Meneses.
I have failed to adopt the motion as writing, but I just want to respect the record that that's on me.
His beard is perfectly manicured.
Also adopt Mr. Steele and Mr. Sharp's motion.
And is that an attorney? With the fuck nigga haircut?
Well, you probably should.
I ain't mad at it.
Reduce that to writing, but Ms. Rosen wants to, if you will include that in order, please, madam.
Yes, Your Honor.
Yeah, I'm going to, in the motion to suppress and motion to quash, okay?
And Your Honor,
You can-
would you allow me to incorporate Mr. Steele's argument into the record on behalf of Mr. Steele as well, so I do not need to cite the same cases and,
Yes,
thank you.
so we'll include you as well. Okay, anybody else? All right. Okay, before I was interrupted by Mr. Sharp, Mr. Hoover.
Yes, Your Honor.
Okay, do you have the issue of the proffer that you'd like to complete at this point in time? Do I have any, I was going to ask you to complete that issue of the proffer. And then also if there's anybody else who we still need to deal with the issue of the proffer.
I'm not sure which proper.
Ms. Rosenwald, you want to address that, please?
Your Honor, I believe the court is referring to your continued, Mr. Hoover's continued representation of Mr. Sumlin after you were disqualified as to Mr. Blaylock, to see if Mr. Blaylock was on board with you continuing to represent Mr. Sumlin.
Well, Mr. Blaylock's attorney is here, so if the court wants to continue, we can at this point.
Where's Mr. Black's attorney?
It's me, Attorney Justin Hill, Your Honor.
Is it Justin Hill?
Yes.
Okay. And you were counsel for, I'm sorry, Mr. Hill, I apologize.
I'm sorry, can you say that one more time?
You're counsel for whom, I'm sorry?
Mr. Blaylock.
Mr. Blaylock, okay, all right.
Demond Blaylock, yes.
All right, Mr. Ross, do you have a copy of the proffer?
I can take a photo.
Could you please, ma'am? I don't think I have it in the last year. Huh? Oh, yeah.
On a serious note, it's really sad to see that many brothers in shackles like that. Seriously, that's actually really sad. Homie head ain't seen a comb in a little minute, huh? No shade. I mean, I see what you
We kind of jumped the gun a little bit, just to, so that, myself and Ms. Weaver are in sync as to who is present today and who's representing whom. Can we just take roll call as to who's here? So we'll start out with, my left, your right, gentlemen. Or ladies, if you're representing anybody, could you kind of state who you are representing, please?
Smith for the state.
Okay, all right,
A.D. Brown for the state lawyer.
all right. Okay. That wasn't right.
Adrian Love for the state, Your Honor,
Okay.
Deputy District Attorney.
Yes, ma'am.
John Floyd from the state.
Deputy District Attorney Simone Hilton for the state.
Assistant District Attorney Lizzie Rosenwasser for the state.
Okay, all right. Now for the defense counsels and their clients. All right, we'll start off, Madam, I forget, and on the right side.
Chelsea Golden for Mouse Farley.
Oh, I remember having to do that.
Anastasio Spinetis for Mr. Mouse Farley.
Jesus.
Shannon Stiller. Max Shard for Shannon Stiller.
Keep that also. Jeffrey Williams.
I'm Brian Steele. I'm also representing.
Okay. All right, counsels in the back, anybody representing anybody here today, Madam? In the orange? Yeah. I'm sorry, one more time? Yes, ma'am.
Gina Bernard for David Myrick.
Michael Russ for Mr. Bear as well. Good afternoon, Sweet shout out to God, Mr. Dorsey.
All right, continue to the center.
Doug Weinstein for Mr. Demonte Kendrick.
All right. Hold on, Mr. Harvey, I think it's you.
Oh, sorry.
With Mr. Nelson, along with Nicole Westmoreland, she is on Zoom, and you can see that she is on Zoom as well.
Yes, sir, thank you. All right,
Angela Williams for Mr. Ryan.
thank you, Madam.
Sean Hoover, Francis, or something.
Okay,
Justin Hill for Demond Blaylock.
all right. Continue, Madam.
Christy Gladden for Trontavia Stevens.
Thank you, Madam. All right, anybody else to my left, your right? Okay, all right. Just want to make sure who was here along with clients today. All right, okay. Thank you very much, Council.
I apologize. I'm here on the platform, Tiambre Callan, on behalf of Mr. Khalif Adams.
Okay. All right, anybody else on our Zoom platform? I'm sorry that we had such difficulty with today. Anybody else? Is your client, Mr. Adams, on the platform as well?
He is not that I see, Your Honor.
Okay.
He's in the back row.
He's in the what?
He's in the back row.
He's here actually in court. He's in the gallery, Madam.
Thank you, Your Honor.
Okay, all right. One more time, Counsel, your name. I apologize, Madam.
Tiambre Callan.
Well, and can you spell that for us, please?
Sure. First name is Tiambre, that's Teombre. Last name is Callan, Calland.
Okay. All right. Okay. All right. Okay. All right. So we're talking about proper. So Ms. Rosenwasser, do you have that?
Yes, Your Honor, I was able to locate a transcript from a previous hearing.
Okay, all right. So can we take care of Mr. Blaylock's proffer at this point in time?
Yes.
All right, let me go ahead. Mr. Blaylock, where are you, sir? Can I get you to raise your right hand for me, please, sir? Best you're able. Do you solemnly swear or affirm the evidence you'll give in the matter now hearing should be the truth, whole truth, nothing but the truth, so help you God so affirm?
Yes, sir.
All right, you put your hand down. Sir, we're just gonna ask you a series of questions just related to the proffer, nothing else. And then after that's done, I'll make a decision as to you and your counsel, okay? All right, Ms. Rosenwasser, if you go ahead and read that particular cover, he's already been sworn, so.
Sir, I recognize you're currently being represented by, I'm sorry, your name, sir.
Justin Hill.
By Mr. Justin Hill, is that correct? And sir, were you previously represented by Mr. Sean Hoover? Are you aware that Mr. Hoover is still representing your co-defendant, Mr. Antonio Sumlin? Okay. Now, have you been advised of a potential conflict between this attorney still representing Mr. Sumlin? No one has advised you of a potential conflict? So, yes, someone has spoken to you? Okay. Is that your attorney right now has spoken to you about that?
Oh my God.
Okay, who spoke with you about that?
All right, y'all. So I might have to call it a day on that. That was fun, but I do have to get prepared for some other lives, and honestly, that's gonna go over. So I'm gonna check and see what time they have court tomorrow as well. All right, and we'll try to get back into it. But so far, the conclusion I've come to is that the police did some illegal shit to get the evidence that they got, and there we go. Let's see. Yeah, we're gonna talk about Meg tonight. Meg, Tory, Lord, you know what? At this point, I low key want Tory, Meg, and Kelsey locked up. Just lock them all up. Lock them all up. I'm so sick of this story, but we gonna talk about it. What else? That. Okay. Yeah, I gotta find some stuff to do. So anyway, love y'all. We'll see y'all in a little bit. We got a sponsored live in like an hour, and then we'll be back tonight to really talk. And I'm gonna let you guys actually call in tonight, because I know y'all gonna have y'all opinions on Twitch and Megan Tory and Thugger and all this shit, okay? And Master P and them too. All right. Like, comment, subscribe. I will catch you guys later.